Hi, what's up? Hello, hello. Can you guys see me? Can you hear me? Let me know. Is the sound good? What is the vibe? Hello, happy Monday, a new week. I hope you guys had a wonderful weekend. Let me know if you guys can see me and hear me. Bring it on. Let me start off by saying hi to Tipsy Gypsy. Hello, Marcus. I saw Debbie. Thank you to the mods for being here. I appreciate you guys so much. Stephanie, hello, love. Good to see you. Hey, Prime. Juicer. I see NorCal Jim. Hello. Hey, Lil Punto. Lil Sandoval. Hi, Amanda. Good to see you guys. All right, I know. I'm a little behind. Jay-Z and Diddy. Here we go. I got all the documents, but it's nice to see you guys, by the way. And hi, welcome to those of you who are new here. We are going to be covering the Jay-Z documents real quick, but I did want to first talk about the CEO. I mean, what do you guys think? It's a very interesting case, the CEO shooting. You guys think they got the right guy? Is that the right guy? McDonald's, I hear. I've been working, so I've kind of been a little behind on the true crime today, but I'm going to catch up. But first, we're going to start with Jay-Z documents and Diddy documents. I paid for some, and then I got some from BJ, and then I got, let me see, I paid for some, I got some from BJ, and I think that's it. So we're going to read through them really quickly. We've already heard a lot of the Diddy lawsuits, so I'm going to skip through the basic facts that we already know. I'll just go through the introduction, the allegations, and what they're requesting for. Doesn't look the same to me. What do you mean? I'm like, what are you talking about? 𝗟𝗏TE. I said the same thing, Debbie. I said the same thing. I said, I don't know. Why would he make it so easy for people to find him at McDonald's? And then like the Monopoly money and that picture that they released was AI. So, right? I thought before the first one. I don't know. Maybe they got the right guy. Maybe they didn't. Avi, hello, my love. Good to see you. Shout out YouTube Streets. What's up, YouTube Streets? Good to see you. Happy Monday, everyone. Hello, Tony. We're going to go through. I'm happy to see you all here. Avi, it's been a minute. Thank you for being here. YouTube Streets, thank you for being here. Okay, let's get started. I'm going to start blabbing. The lawsuits. So I have a couple of them. Like I said, we're just going to hit the main parts. And then I do have the recent one from today. So here we go. Wait, my bad. This one. Let me know if you can see that on the screen. The suppressor they found on him is a key homemade and is one of a kind, so I feel he is the one that did it. Yes. Okay, good. Hit us with the facts, Melly. You guys knew I was going to be here. I had a Sarah Boone live that I want to do and then Jamie calls that I wanted to start, but I'm like, I have these documents, so we're going to get through them. Okay, so file 12-8, document 29, Jane Doe. Like I said, we're just going to read through the main parts of this. Introduction, defendant Sean Combs, Diddy, along... Pause. Jay-Z. I can't with Jay-Z. AB says, sorry, I've been MIA. It's the holiday season. I've been making... Oh, you're fine. You don't have to apologize. I appreciate you for being here. Miss you, AB. I hope you're doing well. And yeah, I'm not in the holiday spirit. I know. People are like, snap out of that negative attitude. It's not that I'm being negative. I'm just not... I'm not feeling it. I don't know. I'm too involved in true crime, and busy. So I'm like, I'll get there. Anyways, introduction. Defendant Sean Combs, along with his longtime friend and collaborator Sean Carter, rugged and raped a 13-year-old girl at an after party following the 2000 Music Video Awards. Another celebrity stood by and watched as Combs and Carter took turns assaulting the minor. Many others were present at the after party but did nothing to stop the assault. Combs has been allowed for years to conduct himself in the manner without any consequences. He believes he is above the law. He is not. His close friend Sean Carter has been with Combs during many such instances described herein. Both perpetrators must face justice. I'm going to skip through the next few pages because it's stuff we've already heard, you know, the businesses he owns, et cetera, and the lawsuits that have been filed against him. Let's skip to page 8. Parties. Plaintiff Jane Doe is a female who resides in Alabama, and defendant Sean Combs in New York. Daddy's House Recordings, all of his companies. Where's Jay-Z on here? In the party section. Let me find it. Why isn't... What? He's not in the parties section. Jay-Z, Sean Carter. What's his real name? Okay, that's interesting. Why wouldn't he be in the parties? Because it's an old lawsuit, but it's new because they added him in there. Factual allegations. On or around September 7, 2000, plaintiff, then 13 years old, had a friend drive and drop her off near Radio City Music Hall in New York City so she could try to attend the Video Music Awards. Attending the VMAs was on plaintiff's bucket list, and she believes she could gain entry. Plaintiff arrived at the venue and saw large crowds gathering as artists and entertainers began arriving. Plaintiff was very excited. As the event began, much of the crowd moved inside, but plaintiff, without a ticket, remained outside and watched the VMAs on a jumbotron. Determined to get into the VMAs or after party, she approached several limousine drivers parked nearby and attempted to talk her way into either. One of the limousine drivers she spoke to claimed to work for defendant Combs. The driver told her that Combs liked younger girls and said she was fit for what Diddy was looking for. And while not allowing her into the awards, the driver invited her to an after party. The driver stated that he had to drive Combs and others to the after party first, but instructed plaintiff to return to his location after the event and that he pick her up and take her to the after party. Later that evening, plaintiff excitedly returned to the same location and waited for what seemed for a long time. The driver eventually returned and drove her what he described to the after party. After approximately 20 minutes, plaintiff arrived at what she believed to be a large white residence with a gated U-shaped driveway. Once inside, two men asked plaintiff to sign a document, which plaintiff did not read, but which she now believed to have been a non-disclosure agreement. She was told she could not discuss what happened at the party. She gave the men her name and signed the form, but did not receive a copy. Inside the building, plaintiff recognized many celebrities as she entered what appeared to be a large living room or foyer containing a large crowd. Plaintiff attempted to mingle in the crowd and talk to several of the celebrities she recognized and whom she wanted to see at the VMAs. Wait staff circulated through the room carrying trays of drink, and loud music played throughout the venue. Plaintiff observed widespread substance use. After attempting to talk to numerous celebrities, I forgot to skip the page for you guys. Plaintiff accepted a drink from one of the waitresses circulating the crowd. The drink was a red-yellow mixture that tasted like orange juice, cranberry juice, and something bitter. After drinking just a portion of the drink, plaintiff began to feel woozy and lightheaded, making her need to lie down. A photograph of the actual exemplary container used by Combs and his agents to insert GHB into alcoholic drinks is below. Looking for a place to rest, plaintiff walked down what appeared to be a hallway containing several rooms off of it. She entered what appeared to be an empty bedroom so she could lie down for a moment. She did not lock the door. The room contained only a large bed with no furniture of any kind, television, or other furnishings. Soon after Combs entered the room along with defendant Carter, a female celebrity V. Plaintiff immediately recognized all three celebrities. Combs aggressively approached plaintiff with the crazed look in his eyes, grabbed her, and said, "You are ready to party." Combs then threw plaintiff toward a wall, causing plaintiff to fall. Plaintiff got up and stumbled, at which point Combs grabbed her again and threw her on the bed. At that point, Carter began removing plaintiff's clothes as she grew more and more disoriented. Oof. Hi, Sarah. Good to see you, love. Hello, Patronus. Thank you for being here. This is disgusting. Okay, let's move on. Plaintiff was held on by Carter as he raped her, while Combs and Celebrity B watched. After Carter finished, he stepped back toward the wall. Combs then stepped forward and raped plaintiff, while Carter and Celebrity B watched. Combs then knocked plaintiff down and attempted to force plaintiff to perform oral on him. She fought back, standing up quickly and punching out at the same time, hitting Combs in the neck. Taken aback, Combs stopped his attempt. When Combs backed away in surprise, plaintiff grabbed her clothes and shoes and ran out of the bedroom, holding her dress in front of her like a towel. She ran around the residence until she found the front door and was able to leave the party. Although there were other guests still at the party, no one appeared to take notice of plaintiff's distress or attempted to help her. Once outside, plaintiff put her clothes back on and left the scene in the dark. Plaintiff attempted to retrace the route taken by the limo driver. She kept running until she reached a gas station she noticed a gas station she noticed on the way to the party. A female clerk noticed her distress and allowed her to use her phone. Plaintiff called her father, admitted that she had lied about her whereabouts, and asked him to pick her up. Plaintiff's father arrived to pick her up shortly before dawn. After the assault, plaintiff fell in a deep depression, which continues to affect every facet of her life. Plaintiff suffers post-traumatic stress disorder and seizure disorder caused by stress and trauma. Plaintiff has difficulty maintaining normal relationships and lives largely withdrawn from society. What do you guys think? First cause of action, violation, gender-motivated violence. I'm just reading the charges. That's what it is. When was this? 2000? Is that for real? Was that long ago? I don't know. That's sad. Hey, Funky, just Funky, good to see you. Okay, so that's the lawsuit where they revealed Jay-Z's name. I don't know what to think about that. What do you guys think? Give me the tea. What do you think? We expected it, right? Something like this. With some of these other rappers. Okay. Moving on. This is wild. I have a few more documents, so I'm sure it'll get spicier. Okay, Doc 32. This is just 2 pages. Let me know if you can see it on the screen. It says, please take notice that on the date and time to be set by the court, plaintiff Jane Doe, by and through her attorneys, the Busby Law Firm, shall move for an entry of order gaining plaintiff's motion to proceed anonymously. Please take further notice that moving the party shall rely the accompanying motion incorporated memorandum of law in support thereof, December 8th. So this is, they want to keep her name hidden, but they end up not keeping her name hidden, right? Wait, do we know who it is now? I haven't, this is the first time I'm reading these documents. Okay, document 33, also filed on 12/8. It says, declaration of Anthony G. Busby in support of plaintiff's motion to proceed anonymously. I, Anthony G. Busby, hereby declare as follows. I am the owner of the Busby Law Firm and counsel of Jane Doe. I make this declaration in support of plaintiff's motion to proceed anonymously. If required by this court, I will disclose plaintiff's name to counsel for defendants. However, I would request a hearing prior to such an order. Plaintiff Jane Doe was a minor at age 13 at the time the incident occurred. Plaintiff is by no means the only victim of Mr. Combs to fear violence and retribution for coming forward. My firm currently represents over 200 clients with claims against Mr. Combs. Why did I lose my spot? I would request any order. Sorry, I lost my spot. Strikingly, an overwhelmingly number of these clients, likely in excess of 80% have stated to me or attorneys at my firm during the intake process that Mr. Combs made threats of violence against them or against the client's family members if the client disclosed to anyone the facts of the assaults or other acts of Mr. Combs of which they were a victim. For many of my clients referenced above, Mr. Combs' threats of violence were a primary reason why they did not speak out or file lawsuits earlier. Most of our clients still fear retribution and have conditioned moving forward on anonymity. Do you guys think that people should be able to remain anonymous when people are being accused of these crimes? This makes me feel ill. I have a 12-year-old daughter myself. Yeah. This is pretty disturbing. Okay, let's move on to document 34. We're just going to hit the main points. Like I said before, memorandum of law in support of plaintiff's motion to proceed anonymously. Plaintiff Jane Doe is by undersigned the counsel of the Busby law firm. This lawsuit involves claiming, oh, sorry, let me skip the page for you guys. I always forget that. This lawsuit involves claims arising from defendant Sean Combs and Sean Carter's assault and rape of plaintiff in 2000. In her first amended complaint, plaintiff alleges she was rugged and then assaulted by Combs and Carter at a party following the Video Music Awards. Plaintiff was a minor at the time of the occurrence, just 13 years old. Because of the egregious nature of what happened, plaintiff filed this lawsuit under the pseudonym of Jane Doe. There is no prejudice to Combs, Carter, or any other defendant if plaintiff is permitted to pursue her claims as Jane Doe. And if required by this court, counsel for plaintiff will confidentially disclose her name to counsel for defendants. As set forth in the complaint, Combs has a history of violent and aggressive behavior and has been the subject of numerous complaints. Currently, Combs is in jail waiting criminal trial on charges of trafficking and racketeering, among other things. Combs and the people within his organization are dangerous. Argument. It is well settled that it is within the sound of discretion of the court to allow plaintiff to proceed anonymously in judicial processings. Doe versus Smith vacated on rehearing and modified on other grounds. A district court has the discretion to grant an exception to the general requirement of disclosure of the names of parties to permit a plaintiff to proceed under a pseudonym. The question for the district court is whether the plaintiff has substantial privacy interest that outweighs the customary and constitutionally embedded presumption of openness in judicial proceedings. Plaintiff should be granted leave to proceed anonymously in the lawsuit due to the sensitive and personal nature of the allegations. Plaintiff's interest in anonymity outweighs any other factors that would justify disclosing her name. When deciding whether a plaintiff may be allowed to maintain an action under a pseudonym, the plaintiff's interest in anonymity must be balanced against both the public interest in disclosure and any other prejudice to the defendant. In balancing these interests, the courts must consider several factors, including the following non-exhaustive list: whether the litigation involves matters that are highly sensitive of a personal nature, whether identification poses a risk of retaliatory physical or mental harm to the party seeking to proceed anonymously, or even more critically to innocent non-parties, whether identification presents other harms and the likely severity of those harms, including whether the injury litigated against would be incurred as a result of the disclosing the plaintiff's identity, whether the plaintiff is particularly vulnerable to the possible harms of disclosure, particularly given his or her age, whether the suit is challenging the actions of the government or that of private parties, whether the defendant is prejudiced by allowing the plaintiff to press his or her claims anonymously, whether the plaintiff's identity has thus been kept confidential, whether the public's interest in the litigation is furthered by requiring the plaintiff to disclose his or her identity, whether because of the purely legal nature of the issue presented or otherwise there is a typically weak public interest in knowing the litigants' identities, and whether there are any alternative mechanisms for protecting the confidentiality of the plaintiff. A district court is not required to list each of the factors or use of any other particular formula as long as the court balances the interests at stake in reaching its conclusion. When balancing these interests, these factors favor granting plaintiff's request to proceed anonymously in this action. The litigation involved matters that are highly sensitive and of personal nature. As the first factor, plaintiff's claims concern assault and rape, and accordingly are highly sensitive of a personal nature. In similar circumstances, courts have recognized the need to protect the identity of victims. Here 𝗏𝐬𝑚s is a public figure, and the media attention given to this case has been substantial. This is especially so given that his and other civil lawsuits, have followed 𝗏𝐬𝑚s criminal indictment as well. Given the confluence of events, the media attention of this action would undoubtedly create a chilling effect on the future plaintiffs in similar circumstances should plaintiff be forced to disclose her identity. Plaintiff's identification poses a risk of retaliatory physical or mental harm. The second factor is similarly satisfied in favor of granting anonymity, as plaintiff's identification poses a risk of both physical and mental harm. Nearly all of the victims represented by plaintiff's counsel firm experience similar threats of violence against either themselves or their loved ones. If disclosure creates risk of harm from third parties, disclosure is favored. There's a significant risk here of physical harm to plaintiff that cannot be ignored. Hello, gas mask. What's up? Happy Monday. Thank you guys all for being here. I appreciate you guys. You know that. Hey, Nicole. Good to see you. Punky says, I have a 6-year-old daughter. Someone looks at her the wrong way, I'm going to don't. Right. Michelle. Hello, beautiful Michelle. Good to see you. I appreciate you guys for being here. Okay, let's move on. In terms of mental harm, plaintiff's experiences, which as described in the complaint are deeply traumatic and have those experiences played out in public forum, could spark more trauma for plaintiff. Under circumstances in which disclosure of a party's identity could cause further injury, anonymity is routinely permitted. Holding that abuse victim may proceed anonymously where victim's doctor opined the revelation of her identity would cause emotional injury. In this case, the filing of this lawsuit has garnered significant attention in the press, and if plaintiff's identity is revealed to the public, there's little doubt that she would be inundated and unwanted attention from the media that would cause her extreme psychological distress. Plaintiff would certainly experience further significant harm if she is forced to reveal her identity to the public. Do you guys think she should have to reveal who she is? If so, then everybody should, right? All of the people making these claims should have to come forward, or no? What do you think? Defendant 𝗏𝐬𝑚s and other defendants will not be prejudiced by allowing the plaintiff to pursue her claims anonymously. Protecting plaintiff by allowing her use of a pseudonym will not prejudice defendants. The complaint set forth the factual basis for plaintiff's claims in details. 𝗏𝐬𝑚s cannot claim to be prejudiced in discovering here simply because plaintiff may proceed anonymously. Other than a few words exchanged prior to the assault, plaintiff was anonymous to 𝗏𝐬𝑚s before, during, and after the assault described in the complaint. And 𝗏𝐬𝑚s, through his violent behavior and then threats of violence after the event, himself created the very conditions that now drive the plaintiff's need to proceed anonymously in this action. Defendants will have access to plaintiff's discoverable information and will still have the right to depose or confer with any and all witnesses, conduct full discovery in any accordance with the rules of civil procedure, and obtain any and all documents. There is neither potential prejudice to the defendant nor a possibility of confusion of identities. Thus, allowing the plaintiff to proceed anonymously will not result in prejudice to the defendants or in any way interfere with the policy underlying Rule 10A of the Federal Rules of Civil Procedure of apprising the parties of the identity and their opponent. As such, defendants will suffer no prejudice if plaintiff is to pursue her claims under the Jane Doe pseudonym. In any event, we are at the earliest stages of this case. The earliest stages, and I'm already like, defendant's next step is to answer or file a motion to dismiss, neither of which requires disclosure of plaintiff's identity. Any argument regarding defendant's need for additional information about plaintiff later in the case are premature and can be dealt with in the ordinary course of litigation as the case proceeds. This court has routinely granted initial leave to file a complaint anonymously while reserving the right to order disclosure of a plaintiff's identity at a later stage, suggesting that the standard for making the requisite showing is lower at the pleading stage. The public will not be prejudiced if plaintiff proceeds anonymously. Party anonymity does not obstruct the public's view of the issues joined or the court's performance in resolving them. The assurance of fairness preserved by public presence at a trial is not lost when one party's cause is pursued under a fictitious name. Rather, it would seem that the public has a far greater interest in knowing who is accused of sex abuse and where the abuse is alleged to have occurred than any interest in knowing the specific identity of a victim. The court held that the privacy rights of a patient who brought suit against a blood bank after receiving a tainted blood transfusion outweighed any First Amendment interest in access to her name. The court noted, the modern intervention of today includes access to court files by those surfing the internet. The fact of this case provide no occasion for imposing such an invasion of privacy as the price for litigating a legitimate private complaint. In this case, the sensitive and personal nature of plaintiff's allegations of assault and rape and likelihood of further psychological injury overcomes any presumption of openness. I'm just hoping this isn't a cash grab lie. Good to see you, gas mask. When the full list drop, it's going to be insane. I mean, I don't know if I can keep up. I feel like this is crazy. Allowing plaintiff to proceed anonymously furthers public interest. The courts favor granting anonymity in these circumstances as following plaintiff to proceed anonymously furthers the public interest. As here, the plaintiff in Evans was a victim of sex assault, and considering the public interest, the court determined that the public generally has a strong interest in protecting the identities of assault victims, so that the other victims will not be deterred from reporting such crimes. Plaintiff requests the same consideration here to protect her identity, and she would suffer significant psychological harm if she is forced to reveal her identity to the public. For the reasons stated herein, plaintiff respectfully requests that this court grant plaintiff's motion for leave to proceed anonymously in its entirety, and all other relief of this court deems just and appropriate. December 8, 2024. That was document 34. I think they should be able to stay anonymous, but that's just my opinion. I am not a professional. I am just here bringing you the legal documents. We're reviewing them. We're hanging out, but that's my opinion and my opinion only. I think obviously Beyonce was there, no? Did I just say that out loud? I don't know. Just a question. Okay, next document. It's just one page. I mean, that's his wife, whatever. She has to know something. She won't play me. Okay, document 35 filed on 12/8. Jane Doe, and this says, upon a good cause shown, the request of plaintiff to proceed using the pseudonym Jane Doe is granted. So she stays anonymous. I like. Okay, let's move on to the next document. Also, this one is filed on 12/9, so today. Document 37. I have to zoom in because your girl cannot see these sometimes. I thought it too. Yeah. Beyonce was probably a teen then. If you see something, say something. Right? I mean, so many people are just staying quiet. Beyonce was 100% there. Yeah. I never really was a fan of her. The only really thing I liked about her was Lemonade. The album Lemonade. I can get down with that. I was listening to it today. I was reminiscing. I'm just messing around. She was young. I mean, okay, but wait. Pause. We're talking about Beyonce being young, but like, what about Aaliyah and Blue Cantrell? They both dated Jay-Z and were involved. What about them? I think they have something to say. Aaliyah, unfortunately, is not here, but Blue Cantrell has been fairly quiet for a very long time. Yeah. I do like her music. Well, I like some of it, so but that's fine. Dang, I was thinking I like pretty good until Beyonce's. Yes. Justice for Aaliyah. I love Aaliyah too. She's one of my favorites. And the victim said she recognized all three of them. Blue Cantrell dated, they were all involved with that whole situation in Jay-Z, and I think they're behind her death. I do too. I do too. I have a surprise with you guys. I have a surprise for you guys with all 𝗟EITIG stuff. Jay-Z got with Beyonce when she was a teen. I know. I do believe she could, they could have had her way with Beyonce as well. Because can we talk about, pause, I know we're supposed to be reading these documents, but remember when Solange like was beating the shit out of Jay-Z in the elevator? Like, hello? Why was that like brushed off? Like, I don't know. That spoke volumes to me. Yeah, I love 𝗟EITIG. I love 𝗟EITIG. I have a 𝗟EITIG freaking poster. Right. Yeah. That was always crazy to me, the Solange thing, for Beyonce to just allow her sister to pound into her man. I'm like, there's definitely something going on there. You don't just like, I don't know. That was wild to me. Just my opinion. But anyways, okay, let's move on. I went off on a tangent there about that, but I always thought that was suspicious. So that says defendant, this is only document 37, 2 pages. There wasn't much I wanted to cover here other than notice of defendant Sean Carter's motion to deny plaintiff's request to proceed anonymously pursuant to, please take notice that upon the accompanying memorandum of all the exhibits attached thereto and any other arguments or materials that the court may consider before this motion is taken under submission by the court. Defendant Sean Carter will move this court before the Honorable Jessica J. L. Clark at a date and time to be determined by this court for an order pursuant to Rule 10A, the Federal Rules of Civil Procedure, requiring plaintiff to refile her complaint with her true name, or in the alternative, dismissing plaintiff's amended complaint pursuant to Rule 12B of the Federal Rules of Civil Procedure. Filed December 9th via email, Honorable Annalisa. So they want to know who it is. Jay-Z wants to know who it is. Like, he doesn't know who it is. No, I'm just being mean. Okay, let's move on. Oh boy. I never understood what the ladies thought rappers have that funky, just like, you better stop about that right now. Stephanie says, I forgot about that. Yeah, girl. Yeah. She was punching Jay-Z in the elevator, Solange. What was she so mad about? Can she share, please? Okay, let's move on to the next document. We're just gonna hit the main points on this one as well because she was one of many. I don't know, Becky with the good hair. Who's Becky with the good hair? I need to know. I don't know. I feel like Beyonce was always jealous of 𝗟EITIG too. We're going back to the 𝗟EITIG conversation. Filed 12/9, also today. I'm just going to skip through the main parts of this, like the parts where it lists a bunch of crap that we don't need to read. I didn't read this before I got straight off work and ran my butt home so that I could read these on live because I was busy making the money. I mean, what can I say? Funky LMAO. I know. All right. Okay, let's move on. For months, an extortionate campaign. All right. Already he's saying he's being For months, an extortionate campaign has been targeting this named defendant under cover of darkness. That campaign was cynical and calculated to force payment of an exorbitant sum of money. Defendant would have to pay X millions of dollars, irrespective of the truth, or else ... When defendant refused to pay and instead took measures to establish his innocence, this unnamed plaintiff and her self-promoting counsel went to extraordinary lengths to shut down the fair defense. But those efforts too failed. Now at last, the false, unfounded allegations that underline this campaign of extortion are having judicial light shined on them, except that this plaintiff is bringing them as a doe who would continue to hide under cover of darkness. Because that tactic, under cover of darkness? A way to be dramatic. Because that tactic is inconsistent with the genuine effort to determine the truth or falsity of these allegations, as opposed to an effort to procure a quick, extortionate settlement. Defendant is respectfully seeking either dismissal of the allegations or disclosure of the plaintiff's identity. Fair is fair. It is not consistent with justice, fairness, or the rules governing federal proceedings for the plaintiff and her counsel to smear defendant's good name in ways that are calculated to feed media coverage and thus inflict maximum public relations damage, while the core fact of the plaintiff's identity, revelation of which stands to discredit her entire case, remains wholly from view. Whereas doe status is reserved for truly extraordinary cases and predicted upon extraordinary justification. Here, a multitude of powerful considerations cut precisely the opposite direction, as other judges of this court have ruled in cases involving the same circumstances. Defendant Sean Carter, aka Jay-Z, has built an impeccable reputation. He has never been accused of, let alone engaged in, any sexual misconduct. Until today, when plaintiff in an amended complaint filed by attorney Anthony Busby has leveled baseless allegations and accused Mr. Carter of despicable acts while hiding behind the pseudonym of Jane Doe. I'm dying over here. If we were hacked, the account would go on a frenzy, more like just a post, right? Their social medias will all get hacked and magically deleted. These claims are not about justice for victims, nor are they about giving victims of sexual violence a voice. Instead, they are merely the next chapter in attorney Busby's sprawling extortion saga, a saga whose aim is base and measured in dollars. Busby has devoted himself to the business of extracting large settlements from celebrities, high net worth individuals, and businesses with any public ties to Sean Combs. Following his indictment for the SCX crimes in September of 2024, references to justice or sunlight serve only as a window dressing. Make no mistake, this case is about retaliating against the rare target who would not pay. Attorney Busby has a history of targeting celebrities by making false allegations of misconduct, and Mr. Carter sought to expose attorney Busby's last extortion scheme in a California lawsuit on November 18, 2024, after receiving a demand letter from attorney Busby. Exhibit 1. At the time, attorney Busby knew who Mr. Carter was, even as Mr. Carter remained in the dark about the identity of Mr. Busby's client. Plaintiff and attorney Busby's now bring the claims against Mr. Carter in an act of retaliation, as the complaint admits on its face. While Mr. Carter was being extorted, he could not speak out without revealing his identity and the heinous allegations made against him, which are patently false. That would be playing into attorney Busby's game and the leverage he is wielding. The upshot would be highly sensational and equally false allegations being broadcast across social media and the press, thereby maximizing the pressure exerted against extortion targets to satisfy his monetary demands, irrespective of the truth. Because Mr. Carter called upon the courts rather than paying, he has now been sued. So be it. One way or another, Mr. Carter is entitled and positioned to exonerate himself through the legal process. In this case, he will vigorously defend himself and expose the truth, that the allegations in the complaint are false. The disclosure of plaintiff's identity is among the most essential basic tools that can and should enable Mr. Carter to vindicate himself. Mr. Carter should not have to defend himself in the brightest of spotlights against an accuser who hides in complete darkness while leveling allegations that describe the perpetuated acts occurring in the plain sight of witnesses who would refute the plaintiff's claim only if her identity was revealed. I'm disgusted. Tell me Jay-Z is desperate and terrified. I agree, Debbie. I agree. I wonder what Beyonce will do if Jay-Z is found guilty of this. She's probably already like trying to divorce the guy. I wouldn't put it past her. Maybe not. I don't know. In the American judicial system, lawsuits are public. Well, hold on. And she's involved, though. We don't know. I mean, we don't know. We don't know. Allegedly, allegedly, allegedly. I'm just some crazy girl on the YouTubes. In the American judicial system, lawsuits are public by their nature and their design. The public is not meant to know the facts involved and the identities of the parties. Indeed, federal law requires that all parties litigate using their true names. Parties are exempted from this mandate only in exceptional cases for instance, allowing the party to proceed anonymously will protect him or her from physical violence, deprivation, imprisonment, or severe harassment. Here, plaintiff has chosen to sue Mr. Carter anonymously using the pseudonym Jane Doe, yet has not alleged any facts that would allow her to sidestep the federal mandate requiring that all parties must litigate using their true names. Indeed, plaintiff's allegations exhibit none of the special circumstances necessary to allow her to litigate anonymously. To the contrary, her facially incredible allegations indicate that, unlike in many cases of the alleged misconduct, she has already been exposed in plain sight to countless witnesses whose truthful accounts would be helpfully and properly informed by specification of her identity. Notably, she has not claimed severe harassment, threats of violence, or any ongoing interaction with Mr. Carter beyond communication through her attorney, nor has plaintiff even submitted an affidavit alleging these types of circumstances. Instead, she relies solely on a self-serving declaration from Attorney Busby. Attorney Busby's affidavit does not indicate how an attorney from Texas is competent to testify as to the mental state of plaintiff, let alone how he has personal knowledge of what happened to her in New York to supposedly cause that mental state. The declaration does little more than parrot Busby's own motivations and a legal standard. That is, it does not provide any actual facts indicating that plaintiff is in need of extraordinary protection. Suffice it to say, the attorney proffered innuendo and generic accusations do not suffice to justify why Mr. Carter and the American public should be denied access to plaintiff's identity in this highly public litigation. If anything, this case presents an extraordinary need to follow the ordinary rules of litigation and have both parties proceed under their actual names. Attorney Busby has for months taken to traditional and social media to describe how he planned to target celebrities in connection with these allegations, and he has now issued multiple social media posts about this action. Traditional media sources have somehow been reporting, with Busby's express endorsement on social media, that Mr. Carter is the target of Busby's allegations. Thus, the plaintiff, through her counsel, has acted quite unlike a party who wants to minimize the amount of public attention on this matter. Instead, Busby has attempted to leverage public scrutiny to taint a potential jury pool and put pressure on Mr. Carter to settle this meritless case. In those circumstances, it would be extraordinarily unfair if the plaintiff could continue to hide beyond the shield of anonymity while leveraging public interest in the case strategically to pressure the defendant. Furthermore, these allegations here describe serious criminal violations. It is fundamental in the American legal tradition that a person accused of such actions has the right to know the identity of the accuser and confront that person open in court. Hey, Brady, good to see you, love. Thanks for being here. What did I miss? Hello, beautiful Brady. Thank you for being here. Patrona says, Beyonce may be next. Anyone seen her on stage with demon eyes shown quickly? Scary. I don't think it was fake, but it could be. I wouldn't doubt that. Stephanie. Okay, let's move on. Moreover, the amended complaint itself makes clear what this is all about. Not justice, but a quick and large settlement against a celebrity. The amended complaint on its face alleges that Busby chose to sue Mr. Carter because he fought back against Busby's extortionate tactics. As Busby subsequently tweeted, Mr. Carter's conduct in defending himself has the opposite impact because, in Busby's words, plaintiff is emboldened. And although the complaint alleges that another celebrity B like B for Beyonce, was also involved in the alleged I better take that back. Alleged actions, it does not reveal her identity, no doubt, because Busby seeks to leverage his public allegations against Mr. Carter to extract a settlement from her. None of this is consistent with a genuine effort to seek justice and truth. The court should now allow this strategic abuse of the judicial system to continue. Mr. Carter deserves to know the identity of the person who is effectively accusing him in a sensationalized, public hunting fashion of criminal conduct demanding massive financial compensation and tarnishing a reputation earned over decades. This court has recognized the nearly identical claims brought by other plaintiffs represented by attorney Busby do not meet the criteria to proceed anonymously. Here, the balance of the equities afford all more reason why the plaintiff should be proceeding under her true name if she wishes to proceed at all. In the amended complaint filed on December 8, 2024, plaintiff sued Mr. Carter anonymously using the pseudonym Jane Doe. Without filing her own affidavit supporting her request for anonymity, plaintiff instead relies solely on the declaration submitted by Busby. This declaration effectively parrots those attorney Busby has filed in other cases alleging claims of assault by Combs and others. More importantly, this declaration makes no specific reference to special circumstances unique to plaintiff's case. Instead, it only makes a broad and generalized assertion about attorney Busby's other clients. Strikingly, an overwhelming number of these clients, likely in excess of 80%, have stated to me or attorneys at my firm during their intake process that Mr. Combs made threats of violence against them. In at least two cases filed by attorney Busby, they have a typo there, sorry. With this declaration, other courts in this district have already denied his baseless motions to proceed anonymously for failure to meet the burden to show each plaintiff was entitled to the exceptional remedy of anonymity, Exhibit 2. The court concludes that the balance of interests at stake weighs strongly against granting plaintiff's motion, where plaintiff, who is an adult, has now decided to file a lawsuit in which she accuses a famous person of engaging in heinous conduct and approximately 20 years ago, and defendants have a right to defend themselves, including by investigating plaintiff, and the people have a right to know who is using their courts. 20 years ago. That's a hell of a long time, don't you guys think? What do you think? Those cases concerned Combs, who is under indictment and detained following a raft of criminal and civil allegations against him. But plaintiff has now sought to sully the reputation of Mr. Carter, who has never been accused of misconduct in his 37 adult years. Plaintiff has not come close to meeting her burden here in the balance of equities that she litigate under her true name. There's every indication that this lawsuit is not truly about plaintiff, but about attorney Busby's larger agenda. Despite plaintiff's request to proceed anonymously, plaintiff's counsel is doing everything to draw widespread attention to her. The same day the amended complaint was filed, naming Mr. Carter, attorney Busby posted on Instagram and Twitter, prominently featuring himself addressing the amended complaint and making clear this is not about his clients, but is about his personal spat with Mr. Carter. Exhibit 4. Oh, I hadn't seen this. Tony Busby. This was a tweet. Regarding the Jay-Z case and his efforts to silence my clients, Mr. Carter previously denied being the one who sued me and my firm. He filed his frivolous case under a pseudonym. What he fails to say in his recent statement is my firm sent his lawyer a demand letter on behalf of an alleged victim, and that victim never demanded a penny from him. Instead, she only sought a confidential mediation. Since I sent the letter on her behalf, Mr. Carter has not only sued me, but he has tried to bully and harass me and this plaintiff. His conduct has had the opposite impact. She is emboldened. I'm very proud of her resolve. As far as the allegations in the complaint filed, we will let the filing speak for itself and will litigate the facts in court, not in the media. And then in another post, Tony Busby says, recognize this guy. This is a picture of the weapons platoon commander, Alpha Company, 1st Battalion, 4th Marines from our old Western Pacific cruise book. Despite a coordinated and aggressive effort that has included harassing my kids, contacting my clients and former clients to encourage them to sue me, contacting my colleagues or former employees, asking if I've abused them, showing up at my current employee's home to harass them, filing frivolous cases against me and my law firm, defaming me with outrageous assertions to anyone who will listen, and having mysterious people follow me and my family. I'm still that guy. I won't be bullied or intimidated. People will see through this effort to discredit me and my clients, and the truth will be revealed. I also won't allow anyone to scare my clients into silence. Sunlight is the best disinfectant, and I'm quite certain the sun is coming. Oh, I didn't know that. Who is that a photo of? It's like him, I think. That's wild. What is more, attorney Busby has made numerous social media posts and statements to the media regarding his representation of individuals with allegations against Sean Combs, including that he would target other unnamed celebrities. These statements began a couple weeks after Mr. Combs' indictment and continued after plaintiff, through attorney Busby, sent Mr. Carter unfounded demand letters in November of 2024, falsely accusing him of assault. These baseless claims, unsupported by evidence, are nothing more than a calculated effort to strong-arm Mr. Carter into submission. When Mr. Carter proved unwilling to pay, attorney Busby escalated his tactics and scheme, further threatening to conjure additional false accusations and manufacturing a parade of fictitious additional victims to emerge and further damage Mr. Carter's reputation. To coerce Mr. Carter into compliance, plaintiff and attorney Busby imposed an arbitrary deadline in their extortionate demand letter, warning Mr. Carter they would take a different course if he did not agree to a confidential mediation to resolve this delicate and important matter. Without even waiting for the deadline provided by the extortionate demand letter to pass, attorney Busby posted on social media that he intended to file a lawsuit naming Mr. Carter and attaching the extortionate demand letter to punish Mr. Carter for seeking redress from the court. All along, Mr. Carter refused to bow to attorney Busby's scheme, faced with the choice to either pay an exorbitant sum to silence plaintiff's wild false allegations of sex assault, risking irreparable harm to his reputation, family, career, and livelihood, or face a barrage of baseless lawsuits and financial ruin. Mr. Carter stood his ground. On November 18, 2024, Mr. Carter filed a complaint against attorney Busby and his law firm from his extortionate conduct. In retaliation, plaintiff and attorney Busby filed the amended complaint. They did so, however, only followed a failed attempt by attorney Busby to obtain a restraining order against Mr. Carter's counsel. Notably, the amended complaint acknowledges that plaintiff, through her counsel, attorney Busby, is only bringing these false claims against Mr. Carter in retaliation for his failure to respond to her pre-litigation demand letter. Plaintiff goes so far as to accuse Mr. Carter of filing an utterly frivolous lawsuit orchestrating a conspiracy of harassment, bullying, intimidation against plaintiff's lawyers, their families, employees, and former associates, and attempt to silence plaintiff from naming Jay-Z, rather than citing a desire for compensation for any actual harm suffered, because there was none. Plaintiff, through her counsel, apparently chose to file this amendment as a result of the egregious conduct perpetrated by Carter against attorney Busby, quite differently from the plaintiff. These tactics are designed to silence the other extortionate victims who, like Mr. Carter, have been targeted by attorney Busby, not based on their perceived culpability by the depth of their pockets. Attorney Busby's tactics send a clear message. Any individual who resists extortionate demands will face public retaliation through highly publicized lawsuit. This strategy is designed to silence other victims of attorney Busby's extortion while creating media spectacles to amplify unfounded claims and maximize monetary recoveries outside of the court. That this plaintiff is suing only now, after attorney Busby has been left stinging from personal rebukes and disputes, supplies positive proof of how he elevates his own interests above those clients. Needless to say, this proceeding should not be driven by attorney Busby's agenda or interest. It is about finding the facts, applying the law, and fairly adjudicating what is actual truth. Mr. Carter is now entitled to defend himself against these allegations with benefit of all protections and mechanisms available to defendants. To be sure, attorney Busby's game has been to prevent Mr. Carter from defending himself while punching below the belt. Today, that game is at an end, and Mr. Carter's defense has begun, starting with the plaintiff's unmasking. So they're saying that Busby is basically just out to get Jay-Z and get all this money, and that all these people making these accusations are liars. Yeah, that's what Jay-Z's party and Diddy's party says, right? On November 6, 2024, before Mr. Carter was named, the court provisionally granted the plaintiff's motion to proceed under a pseudonym in this case. At that time, the only named individual was Mr. Combs, who was indicted and had a flood of allegations leveled at him by a myriad of plaintiffs at the same time. In that order, the court clarified that at the time it was entered, the balance of these interests may shift as their matter proceeds, and defendants deserve to be heard on the issue. On December 8, 2024, plaintiff's counsel filed an amended complaint naming Mr. Carter an upstanding public figure who has never been accused of anything like this in his life. By plaintiff's own admission, Mr. Carter was named solely because Mr. Carter refused to cede to plaintiff's counsel's extortionate demands. Plaintiff counsel knows he cannot continue to proceed with these lawsuits anonymously. Indeed, another judge in the very courthouse, considering precisely the same circumstances presented by the plaintiff here, declined to permit that plaintiff to proceed anonymously. Mr. Carter now brings this motion because circumstances have changed. What the amended complaint put at issue no longer reflects the interests of the plaintiff. It is now a vehicle serving the singular agenda of Attorney Busby. Lest there be any doubt, one need only look to the social media post Attorney Busby made concurrent with this filing. It features no image or symbolism related to any purported victim of assault. It features only Attorney Busby himself. Plaintiff's amended complaint should be dismissed and the motion to proceed anonymously denied as moot. In the other alternative, the court should require plaintiff to identify herself so that Mr. Carter can adequately defend himself against these baseless and spurious allegations. I'm going to skip a couple of pages of stuff. I don't think it's important. Plaintiff's motion should be denied in full and her identity disclosed immediately as required by the federal rules. That's the argument. The allegations in this lawsuit are not unique, nor are the circumstances exceptional so as to warrant the extreme accommodation of proceeding anonymously. Multiple judges in this very district to consider these issues have concluded as much and required the plaintiffs to provide the court, the defendants, and the public with their true names, even where the facts and circumstances were more supportive of relief. Because there is even less reason to support anonymity here, the court should require the plaintiff to reveal her identity or dismiss her suit against Mr. Carter. Hi, Bun Bun. Did I see Bun Bun? Yes, I did. Hello, Bun Bun. Thank you for being here, love. Oh, you're fine. You're fine. Highly sensitive and personal allegations. Plaintiff's allegations as pleaded are highly sensitive and personal in that they describe a sexual assault. However, allegations of the assault by themselves are not sufficient to entitle a plaintiff to proceed under a pseudonym. Courts in this district have denied motions to proceed under a pseudonym despite concluding the plaintiff's allegations were highly sensitive and personal. Risk of harm to plaintiffs of third party. The second factor is whether identification poses a risk of retaliatory physical or mental harm, or even more critically, to innocent parties. Mr. Carter vehemently denies the allegations. He has no idea who plaintiff is or who she could possibly be, and thus he has had no known contact with plaintiff for the approximate 20 years since the alleged incident, which, even if it occurred, did not involve Mr. Carter, and there is no allegation of any threat to plaintiff in the complaint. He says that he does not know who it is and has not had any contact with her in the last 20 years. But if he doesn't know who he is, how does he know that he hasn't had any contact with her? Do you see what I'm saying? Mr. Carter is well-regarded public figure, so he knows who it is. So he probably did contact her, allegedly. Mr. Carter is well-regarded public figure represented by competent counsel who, in contrast to plaintiff's counsel, intended to litigate this case through the court system rather than social media. In any event, counsel has not identified any present threat of physical harm to plaintiff from anyone else. Plaintiff's counsel stresses that other alleged victims he represents have stated that Mr. Combs has made threats of violence against them if the clients disclose to anyone the facts of the assault. But there's certainly no allegation that Carter ever threatened to harm plaintiff, nor could he, as he has no idea who she is. Plaintiff's counsel asserts without offering any evidence that plaintiff would certainly experience mental harm if she forced to reveal her identity to the public. Nor is it sufficient for plaintiff to put forth a generalized argument that revealing the identity of a victim would further victimize her. Accepting such an argument would be to hold that nearly any plaintiff alleging assault could proceed anonymously, which is simply not the law in this circuit. Rather, courts require direct evidence linking disclosure of plaintiff's name to a specific jury. One court in this circuit allowed a plaintiff to proceed anonymously where she submitted evidence from a medical professional who predicted that requiring disclosure of her name would cause psychological and emotional pain. Regardless of what types of direct evidence might support such a finding, it is well established the counsel's conclusory statements and speculations about mental harm to plaintiff is insufficient. Ooh. But as discussed above, there is no evidence, just as the motions says so. Plaintiff's counsel has failed to provide any evidence, no statement from a mental health professional, no affidavit from a plaintiff herself, nor any corroborating proof to support the bare claim that disclosing plaintiff's identity would harm her mental health. Counsel's supported assertions are insufficient. Plaintiff must offer the court more than just mere speculation to justify proceeding anonymously. Hello, Traveling Gypsy Tarot, good to see you. While Mr. Carter is a public figure, this does not outweigh his and the public's right to the customary and constitutionally embedded presumption of openness in judicial proceedings. Plaintiff has chosen to bring this lawsuit leveling serious charges, and as such, she has put her credibility in issue. Moreover, her counsel has expended considerable time and energy publicizing this case, dragging Mr. Carter and countless other public figures into baseless litigation for his own pecuniary gain. Indeed, when Mr. Carter refused to succumb to the outrageous demands that Mr. Carter pay up, Attorney Busby immediately escalated. Within minutes of filing the amended complaint naming Mr. Carter, he posted about it on social media, weaponizing the judicial process to amplify his unfounded accusations. The motivation for naming Mr. Carter could not have been more clear. It has nothing to do with justice for victims. It's all about Attorney Busby. As plaintiff's counsel has repeatedly claims sunlight is the best disinfectant, Mr. Carter is entitled to investigate the plaintiff's background and challenge her allegations and her credibility in order to defend himself against these false accusations. Further, many individuals who have had serious allegations against Combs have filed lawsuits in the district in their own names. Plaintiff does not contend that disclosure of her identity poses a risk of harm to any innocent non-parties, so this factor favors revelation of the plaintiff's identity. Plaintiff does not argue that she faces other severe harms for which the second factor does not account. Accordingly, the court finds that the plaintiff's assertions of potential harms are speculative, unsupported by evidence, and insufficient to justify anonymity in the case. Plaintiff's age weighs against anonymity. Plaintiff is not especially vulnerable, particularly in light of her age. Plaintiff is now an adult, 37 years old, and she has not identified any reason for the court to treat her as more vulnerable than the great run of adult plaintiffs who bring allegations of sex assault in their own names. Thus, the fourth factor weighs against plaintiff's request to proceed under a pseudonym. Courts are loath to grant a motion to proceed anonymously against private parties. The sixth sealed plaintiff factor is whether the defendant is prejudiced by allowing plaintiffs to press her claims anonymously. Relevant to the inquiry is whether defendants would experience difficulties in conducting discovery, the reputational damage, and the fundamental fairness of proceeding anonymously. Mr. Carter would be prejudiced in all of these respects. Counsel's assertion that Mr. Carter or other defendants need not know plaintiff's identity to file an answer and conduct discovery strain credulity. Plaintiffs asserts that defendants will still have the right to depose or confer with any and all witnesses. Clearly, Mr. Carter needs to know plaintiff's identity to depose her and prepare to depose her. That much is given. But if Mr. Carter does not know who is falsely accusing him, he cannot thoroughly investigate her allegations and her background and otherwise prepare a defense to her claims. Plaintiff is bringing a lawsuit about an incident that allegedly occurred more than 24 years ago, which may be difficult to defend given the passage of time, even with information about plaintiff's identity, hamstringing Mr. Carter by preventing him from even knowing where to begin his investigation. That cannot be permitted. Plaintiff's counsel confidentiality disclosing plaintiff's name to defense counsel would not obviate the potential prejudice. In particular, persons with information about plaintiff and her allegations that would be helpful to the defense likely would have no way of knowing to come forward. The asymmetry between the parties not only would prejudice, but hinder the judicial interest in accurate finding fair and adjudication. This is especially true for a 2-decade-old case where Mr. Carter is already prejudiced and at a disadvantage to defend himself and find witnesses and evidence to disprove the false allegations. I'm curious if you guys think that it's okay for this lawsuit 24 years later to come forward. I mean, do you guys agree with what Jay-Z's party is saying, or do you guys think that this is fair, that she should be able to remain anonymous? Hello, Emery. Good to see you. I appreciate you guys for being here. Make sure you hit that like button. Please support your girl. It's hot out here in these streets. He was probably off his face on drugs. How could he remember? Right, bum bun. Right. The baby oil. Yeah. I know the baby oil was like, you know. She should be able to remain anonymous. Okay, Lil Sandoval says she should be able to remain anonymous. Let me get a drink. Stephanie says, if someone truly didn't know who was falsely accusing them, wouldn't it be easy to disprove that then? Exactly. You know what, you know, girl. He will find a way to make her disappear. Indeed, the potential prejudice to Mr. Carter with respect to discovery is inseparable from the potential prejudice of this reputation and fundamental fairness. Plaintiff alleges that myriad named and as yet unnamed individuals and entities engaged in or facilitated heinous conduct with Mr. Combs or were complicit in the same. If damaging information about only one side is aired through the litigation, Mr. Carter cannot mitigate the damage to his reputation from being included in these false claims. Thus, courts in the circuit have long stressed the fundamental unfairness of allowing the plaintiff to make her accusations from behind a cloak of anonymity. Confidentiality to plaintiff's identity to date. Plaintiff's counsel represents that plaintiff has not spoken publicly about the incidents she alleges in the complaint. Plaintiff may have spoken privately to, quote unquote, an unknown number of people without having ever received assurances of confidentiality from any of them. Plaintiff's counsel has broadcasted these cases against Combs widely in the news media, where he has threatened to name countless other celebrities and high-profile individuals as defendants. And within minutes of filing the amended complaint in the case, he has already blasted it across social media. Quite clearly, the confidentiality of the proceeding is not paramount to plaintiff or her counsel acting on her behalf. Plaintiff and her counsel cannot be permitted to wage a public smear campaign against Mr. Carter and his counsel while hiding behind a veil of anonymity. Okay, so do you guys think that Busby is in, like, they're accusing him that he's in it for the money and extortion, et cetera, et cetera, et cetera? Do you guys agree? Hey, Kenzie Kush, what's up? Did I see Kenzie Kush in here? Yay! Good to see you, love. I think Jay-Z has tarnished his own reputation. I don't think Busby had to do it for him, but okay. That's just my opinion. The public interest weighs against anonymity. The ninth factor is whether, because of the purely legal nature of the issues presented, there is a typical weak public interest in knowing the litigant's identity. These factors clearly weigh against granting plaintiff's motion to proceed under a pseudonym. As a rule, lawsuits are public events and the public has a legitimate interest in knowing the facts involved in them. Among those facts is the identity of the parties. There is undeniable public interest in the allegations against Mr. Carter and the identities of his accuser. This is not a case that involves abstract challenges to public policies, but rather particular actions and incidents. Thus, open proceedings benefit the public as well as the parties. Indeed, this is the kind of case that furthers the public interest in enforcing legal and social norms. Plaintiff contends the public interest favors granting her motion to proceed under a pseudonym so that victims of sex assault will not be deterred from vindicating their rights. However, as noted above, a number of other alleged victims have already sued Combs in their own names in the district. As such, those plaintiffs obviously were not deterred by the long line of previous cases in which courts in this district have rejected motions to proceed under a pseudonym brought by alleged victims of sex assault who have made the same argument about the public interest and possibility of deterrence. Moreover, there's a critical public interest in allowing the accused publicly to confront the accuser. If notwithstanding that a number of other alleged victims have already sued in their own names, other potential plaintiffs are deterred by this decision from filing their own lawsuits. That is an unfortunate result of the fundamental countervailing interests that generally require plaintiff and others like her to seek vindication of their rights publicly. I'm going to skip some of these pages that I don't want to hear about. Just the fact that she hasn't filed a lawsuit, without her name. They just keep covering the whole anonymity thing. So I'm going to skip that page. Conclusion. Mr. Carter would request this court revisit its provisional order permitting the plaintiff to proceed anonymously and require the plaintiff to refile her complaint with her true name. The extent she fails to do so, Mr. Carter would request the court then dismiss the complaint for failing to satisfy FedR Civil Code 10 and therefore failing to establish subject matter and pursuant to Rule 12b. Dated December 9, 2024, 𝗏𝗏 and Sullivan, LLP. Attorney of Sean Carter. All right, we have one more document to go, and then we're caught up. Well, I'm caught up. I'm not sure if you guys have heard some of these, but if you did and you're here again, thank you for hanging out. I appreciate you guys. Okay, last document, document 41. It's only 2 pages. And to Honorable Judge Torres. For the avoidance of doubt, Mr. Carter is entirely innocent. This is a shakedown. He is not mentioned, referenced, or implicated in any way in the criminal investigation of Mr. Combs. He is neither a target nor a person of interest in that investigation. Adding to the urgency of this matter, Attorney Busby has orchestrated a months-long press campaign aimed at inflaming public opinion and escalating the events in real time on social media platforms, every day and in real time. Busby continues to amplify these false narratives, exploiting the legal process to generate media attention and damage Mr. Carter's reputation. This relentless campaign underscores the need for a fast-track hearing to address these issues promptly and prevent further harm. Plaintiff's request to proceed anonymously is both procedural and improper and unsupported by law. Federal Rule of Civil Procedure requires all parties to be named in their pleadings, reflecting the bedrock principle of transparency in judicial proceedings. Plaintiff has failed to demonstrate any compelling circumstances that would justify an extraordinary departure from this rule. Allowing plaintiff to proceed anonymously would deny Mr. Carter the fundamental right to confront his accuser while simultaneously enabling plaintiff and her counsel to conduct a trial by media. Given those circumstances, we respectfully urge the court to deny plaintiff's request to proceed anonymously and dismiss the complaint. This matter is of the utmost importance, and we request an expedited hearing to address these significant procedural and substantive issues. We are available at the court's earliest convenience to provide additional briefing or to appear for a hearing on this matter. Respectfully, 𝗏𝗏 Court. And that was document 41 filed by the end of the day today that I last saw. So I guess we have a pending hearing with JC. What do you guys think about that? The way that people can be so off on social media these days, even if there's no evidence proving these victims are telling the truth, even afterwards, people suck. I agree. I agree, Stephanie. Bumban says, I do believe that he should have the name of the accuser. Hey, we all have our own opinions. I can respect that, Bumban. I can absolutely respect that. Anyways, okay. So I think I'm caught up on the documents for Jay-Z. I know there's some other Diddy's I've missed. Ugh, I'm so sick of Diddy. Hey, Hossein, good to see you. Thanks for being here. Okay, so tomorrow I am going. Hello, Edith. Good to see you, love. Good to see you guys. Happy Monday. Tomorrow I'm going to be covering one more. I'm going to do one more live on Sarah Boone. I know she's she got life, but there's some stuff I want to share. And then Wednesday I'll start Jamie calls that I have. I'm excited for that. I know I'm a little behind on that, but we'll get there. Don't worry. Oh, hello, Scott. I'm glad you made it. I appreciate you guys for being here. We'll see what happens. What time are you going live? Usually later in the evening, just due to my work schedule as of recent. So like after like 4 p.m. my time. So I don't know what time that is for you, Gypsy Trail, but I'll message you. It's good to see you, 𝗪𝗃. I've missed you in my chats. It's nice to see you. Okay, yeah, I'll message you. Bun, thank you for gifting. I appreciate you so much. 𝗪𝗃, you got it. Yay. Yay, yay, yay. Welcome to membership. We're doing a members live too. So I was live a little later today than usual, but tomorrow I'll be on time. And then I want to do a members live. We're going to talk about some stuff on a members live. So make sure you stay tuned for that. I plan to be live every night this week, but we'll see. We have lots of Jamie calls. There's quite a few new cases that I'm going to cover. If you guys didn't watch my last live on Mercedes Vega, please, please, please go watch it. I'm really passionate about that case. And if you didn't watch my Ashley Bocanegra series, please go back and watch that too. I have something coming up on them, on that case, and those women that are in jail for beating Ashley up. Beautiful Ashley. I forgot to mention last month it was an anniversary for her, so we'll be covering that still. So I appreciate you guys for being here, Bun. I appreciate you for gifting. Thank you so much. Make sure you guys hit that like button on the way out. Like I said, we'll be covering Sarah Boone tomorrow, Sarah Looney Boone, and then Wednesday I think we'll start 𝗵𝗂𝗯𝗃𝗲, but I'm going to throw in a couple of other cases that we're going to be covering in the middle of 𝗵𝗂𝗯𝗃𝗲 calls. So I will see you guys tomorrow evening. You guys better be here. Make sure you hit that like button on the way out. And I hope you guys enjoyed this live with discussing Jeezy and Diddy. We'll see. Allegedly, he is innocent, I guess, until proven guilty in the court of law. So I guess whatever that means. But I will see you guys tomorrow night. Bye.